Hey everybody, Rob Bonta, California Attorney General. Thank you all for joining us today on the heels of our success in securing a temporary restraining order to block President Trump and Defense Secretary Hegseth from deploying members of the California National Guard in Los Angeles and directing them to return control of the Guard to the governor of California, Governor Gavin Newsom. The order goes into effect at noon tomorrow. This isn't the final decision in our case, and it doesn't yet make a determination on the Marines that have been deployed. However, it's still a very important step forward in protecting our communities and our rights while we continue to make our case in court. It's also a critical early indication that upon quick review of the facts in our case, the court sees the merits of our argument regarding the unlawful activation of the National Guard. As we argue in our lawsuit, the Trump administration had no right to federalize 4,000 California National Guards people without authorization from Governor Newsom. Trump's actions were illegal, trampled on our state sovereignty, escalated tension on the ground, and promoted rather than quelled unrest. With his orders, the president invoked a law that can only be used in the event of a potential rebellion, threats of a foreign invasion, or if the federal government cannot enforce federal laws. None of that is the case here. We aren't in the throes of a rebellion. We are not under threat of an invasion. Nothing is preventing the federal government from enforcing federal law. The situation in Los Angeles last weekend didn't warrant the deployment of military troops, and their arrival only inflamed the situation. Local law enforcement are trained, experienced, and resourced to enforce the law within our borders. They're trained to control crowds, protect public safety, and protect the right to peaceful protest. That's their job. That's what they do, not our military's job. Our military forces are trained to defend us in war and respond to natural disasters. California National Guard troops work every day under the command of the governor to prevent fentanyl from crossing our border and infiltrating our neighborhoods. They stand ready to respond to natural disasters, to fires, floods, and earthquakes at a moment's notice. And when necessary, they stand ready for the governor to send them where they're needed, as he has done multiple times, including as recently as January of this year, when he sent them to the wildfires in Southern California, activating these troops over the weekend for protests that were largely peaceful and that local law enforcement had at the time confirmed were under control, is unfair and disrespectful to our service members and the critical work that needs their immediate attention. Don't just take my word for it. Just yesterday, a group of former secretaries of the Army and Navy and retired four-star admirals and generals joined together to publicly support our lawsuit. In the brief they filed with the court, they warned against unlawful domestic deployments that threaten, quote, core national security and disaster relief missions, put the military at risk of politicization, and pose serious risks to both service members and civilians, end quote. The truth is, the president is looking for any pretense to place military forces on American streets to intimidate and quiet those who disagree with him. It's not just immoral, it's dangerous, and it's illegal. I'm proud that today we were able to swiftly block the president's unlawful deployment of the California National Guard and hold him accountable to the law. While this is an early success, it's far from the end of the road. It's become clear that the president and federal administration are all too willing to break the law to intimidate and silence those who speak out against them. It's unlawful, undemocratic, and un-American. From the civil rights movement to the suffrage movement to the farm workers movement, peaceful protests have defined who we are as Americans. The right to raise your voice and stand together in community to call out injustice and demand accountability embodies everything we stand for as a nation of the people, by the people, and for the people. What makes America great is our U.S. Constitution. As California's top law enforcement officer, I'll always stand up for our founding document and the First Amendment right to freedom of speech, and to peacefully assemble, the very cornerstones of a healthy democracy. To any who are outraged with the conduct of President Trump and his administration, who feel moved to stand up and speak out, I urge you to do so peacefully, safely, and lawfully. For any who see this moment as an opportunity to create chaos or cause violence, know that local law enforcement are on the ground, ready to take action to protect public safety and uphold the right to peaceful protest. Before I open it to questions, I want to thank the incredible public servants at California DOJ, particularly the Civil Rights Enforcement Section, Office of the Solicitor General, and the Government Law Section, who have been working around the clock with sleepless nights through the night and the weekend to protect the rights we hold dear as Americans. Christopher Kissel, James Bowen, Megan Strong, Brendan Ham, Kendall Micklethwaite, Megan Richards, Lorraine Lopez, Stephen Kearns, Luke Friedman, Nicholas Espiritu, Marissa Malouf, Robin Goldfaden, Norma Franklin, James Stanley, Laura Fair, Nick Green, Christina Bull-Arndt, Samuel Harbert, Michael Mongin, and Jacqueline Gonzalez, an incredible team who I thank from the bottom of my heart. I couldn't do this work without them. I have deep appreciation for them. And with that, I'd be happy to take your questions.
If you'd like to ask a question, you may do so by clicking on the raise hand icon at the bottom of your screen. You may also use the Q&A feature at the bottom to ask your question. First question comes from Jeremy. Jeremy, you are now unmuted.
Hello, Mr. Attorney General. Can you hear me? Wait. Hello, Mr. Attorney General. Can you hear me?
I can hear you. Hi, Jeremy.
Hey, Mr. Attorney General. Thanks for making some time on a long day. This is obviously the court case that was dominating the headlines today, but it's not the only thing you've been dealing with. The Trump administration is also trying to roll back some of California's clean air policies, which are contesting. There's reports about them trying to pull education funding. You in California are no strangers to battling the Trump administration and trying to protect California's policies. I'm wondering if what we have seen in the last week, including what we're talking about tonight, is more of the same that we saw during the first Trump administration, or do you feel that we've entered into a new phase or a new set of stakes in terms of what we're seeing coming from the federal government?
There's a through line between Trump 1.0 and Trump 2.0, and Trump 2.0 is different in some material respects. The through line is he continues to break the law. He is blatant and brazen and frequent and consistent in his violations of the law and his trampling of the Constitution. That happened in Trump 1.0. That's happening now in Trump 2.0. But the speed and the volume in Trump 2.0 is materially different. There were about 120 plus cases that the state of California filed against the Trump administration in Trump 1.0. We are on pace to hit that mark in half the time. And so it's almost double the pace, if not more. We've sued the Trump administration 26 times in 20 weeks, more than once a week. And the shamelessness and the brazenness of the violations, they seem more severe. And that's why we're broadly winning consistently in court, securing temporary restraining orders, securing preliminary injunctions. Our commitment is to meet him in court and take our president to court each and every time he breaks the law. And look, we don't want to. We'd rather we have a president who follows the law and complies with the Constitution. It's not a good thing for the great United States of America to have a president, the most powerful elected official on the face of the earth, to violate the law so frequently, to have such contempt for the U.S. Constitution and the rule of law. But it's incumbent upon me and my fellow Democratic attorneys general who've been fighting this fight to be consistent and resolute, unapologetic, and immovable in our commitment to take him to court each and every time he breaks the law. And so he's done it again here. We filed another suit today because he did it earlier today when he signed the resolutions that are purportedly pursuant to the Congressional Review Act, but are not, when it tried to strike down our waivers unlawfully. And so we sued him there as well. And we'll sue him for any unlawful action and any unlawful conduct that he takes when the state of California is hurt.
Thank you. Next question comes from Michael. You are now unmuted.
Good evening, Attorney General. Thank you for doing this with us. I have a question about process. So, just so we all understand it, and some probably understand it better than I do, but there's the process and the appeal process for this TRO or injunction, which runs parallel to the district court judge determining the the legality, the overall legality, and whatever he decides to rule on, that could also be appealed up to the Ninth Circuit and then ultimately the Supreme Court. So it seems like we could have a parallel track of appeals, one for the short-term temporary thing and one for the overall thing. Can you just like speak to that process a bit more so I don't make a mistake?
Yeah, you've described it pretty well. There's a lot of moving parts here. We have our sort of, our complaint and the overall case that's moving. It continues to move. Today was a preliminary order in the form of a temporary restraining order. The judge has set a hearing for a preliminary injunction hearing on a preliminary injunction motion for next week. And as facts develop, we'll be able to present those to the court and have consideration for a preliminary injunction, which will last generally throughout the course of the litigation until a final decision is made. And then for each of these orders, whether it be a temporary restraining order or a preliminary injunction order, or a final order, eventually, sort of three categories: temporary restraining order, preliminary injunction, final order. Each can be appealed by the federal government, and so they've already appealed this temporary restraining order, and they're seeking both an administrative stay and a stay pending appeal, meaning they want to maintain the status quo while the appeal is considered. So, but you're right, as they pursue that administrative stay and that appeal of our temporary restraining order, we continue to move forward in the case, including towards next week's preliminary injunction hearing and ultimately to a final decision by the court on our case.
Thank you.
Thank you.
Next question comes from Laura. Laura, you are now unmuted.
Hi there, Attorney General. Thank you so much for taking our questions. I'm curious if you guys have heard anything about whether this ruling has already had any effect on the situation on the streets in LA, if the National Guard is still deployed, or what information you've gotten about what those troops are currently doing. Thank you.
Don't have any additional information to add right now. I think the order came down maybe an hour and a half ago. Not sure that there has been any movement with respect to the National Guard. I do want to just reiterate what the court's order says is that his order is stayed until tomorrow at noon. So that means it doesn't take effect or have the force behind it until tomorrow at noon. So technically, if there weren't any immediate changes before noon, that would be compliant with the order. But it also takes time to mobilize, to issue orders, to have them handed down, for logistics to be planned for any movement that there might be. So the judge may have been giving some time to the federal government to move something that can't be done immediately with the flip of a switch and the snap of a finger. So not aware. Maybe some of the local law enforcement or others or my office can update you in the coming hours.
Thank you. Next question comes from Elex. You are now unmuted.
Hi, Attorney General Bonta. Alex Michelson here from Fox 11. I'm kind of confused on, so you talk about the stay till tomorrow at noon. At that point, could there be another stay in terms of appeal to keep it going, or how should we communicate this in terms of tomorrow at noon Newsom gets it no matter what, or at that point, this thing could still continue? And secondly, are you concerned about the Insurrection Act and President Trump invoking that and potentially, keeping the guard that way?
Thanks, Alex. Absent any action from an appellate court, the order goes into effect tomorrow at noon. And there shall be no deployment of the Guard in LA, and the command of the California National Guard shall be returned to Governor Gavin Newsom. And at noon tomorrow, he'll be able to issue his orders to the California National Guard because they will be under his command. Now, as I mentioned, the federal government has already moved swiftly to appeal. They moved for an administrative stay. They moved for a stay pending appeal. So if the Ninth Circuit acts between now and tomorrow at noon and either rejects their request, that's one scenario. That would mean that at noon, Governor Newsom has command of the National Guard. But if they grant their stay, then it means that the order is temporarily stayed and it does not go into effect at noon. So we'll just have to wait and see. Don't have a crystal ball on that one. But there's one of two scenarios: either the stay is granted or the stay is denied. And if it's granted, that means the command does not hand over at noon. If it's denied, the command goes back to Governor Newsom at noon tomorrow. The Insurrection Act is something we're aware of. It appears that through some of the rhetoric and language, it seems like there could be some socializing of that action, some laying of the groundwork, if you will, of the Insurrection Act. I will say that there's only two bases for invoking the Insurrection Act. One is basically the same as one of the elements that was rejected in the case already in the order by Judge Breyer today, which is that the federal government is unable to, with the regular forces, execute the laws of the United States. That's already been rejected. So they would need to rely on the other element, which is there's been a deprivation of rights of Americans, and that really came into focus in during the Civil Rights Movement, 50s and 60s, when desegregation orders were not being complied with by state governors, and the National Guard had to come in to prevent Black Americans from having being deprived of their civil rights and their constitutional rights. That situation does not exist here. So I don't see how they could lawfully and appropriately invoke the Insurrection Act, but they invoked 10 U.S.C. 12406 when there was no basis for it. And they tried, even if it's not lawful. That is their MO. That is what they do. They take unlawful actions. Why? Because they like the power that it gives them. They like to say there are rebellions or invasions or emergencies or insurrections because that triggers more executive authority. And that's really the end goal for them. But unfortunately for them, and fortunately for us, we are stopping them when they take unlawful actions, as we have done here. And we believe we will be successful if they try to invoke the Insurrection Act unlawfully as well.
Thank you.
Thank you.
I think that's all the questions we have right now.
Okay, thanks for joining. Thanks for staying up into the evening. Appreciate the time and the attention. Thank you.